Welcome to Lecture 5 in this series on critical reflections on the EU's data protection regime. Lex Zard, or Lexo, his chapter studies surveillance advertising from the GDPR's entry into application in 2018 to the end of 2023, with an author's note recording developments in 2024. The chapter advances a deliberately strong argument. The dominant behavioral advertising model repeatedly failed to establish a stable, lawful basis under Article 6. Zard follows the movement from contractual necessity to legitimate interest and then to consent or pay. He also widens the analysis beyond data protection, asking what consumer law, e-privacy, platform regulation, and systemic risk duties add when consent cannot resolve every harm. Surveillance advertising differs from contextual advertising. The system monitors behavior, links observations across services or devices, infers interests and traits, assigns the person to segments, and uses automated auctions to select an advert. Inputs can include browsing and social media activity, location data, cursor movement, and keystroke patterns. Large platforms operate closed advertising ecosystems, while the open ad tech market connects publishers, advertisers, and intermediaries through real-time bidding. The chapter also identifies a wide harm profile: privacy loss, emotional distress, discrimination, economic exploitation, market concentration, environmental effects, integrity harms, and damage to dignity or democratic conditions. That breadth explains why a lawful basis analysis, although essential, cannot exhaust the regulatory problem. Article 6 begins from prohibition. Processing needs a lawful basis. Zard dismisses legal obligation, vital interest, and public task as realistic foundations for commercial behavioral advertising. The contest therefore centers on three roots. Contractual necessity asks whether profiling is objectively necessary to deliver the service promised. Legitimate interest asks whether a genuine interest survives strict necessity and balancing against the data subject's rights. And consent asks whether the person received enough information and genuinely free, specific, and unambiguous choice. The chapter structure matters because the industry did not use these bases in parallel as interchangeable labels. Major actors moved from one route to another as regulators and courts rejected earlier positions. When the GDPR became applicable, Meta framed personalized advertising as part of the contractual service offered by Facebook and Instagram. The Irish Data Protection Commission's draft reasoning accepted much of that logic, but other supervisory authorities objected and the EDPB rejected it in binding decisions. The key distinction concerned necessity. A platform may need some data to operate an account or deliver requested functionality, but open-ended behavioral profiling does not become strictly necessary simply because the contract describes a personalized experience. Less intrusive forms of personalization and advertising remain possible, even if they generate less profit. The final Irish decisions imposed substantial fines and required Meta to stop relying on 6.1b for behavioral advertising. The next route required three cumulative stages: a legitimate purpose, necessity, and a balance against the user's interests and fundamental rights. Marketing or profit may qualify as a legitimate interest in the abstract, but that does not settle the test. Contextual or segmented advertising can pursue marketing objectives with less behavioral data, which weakens the necessity claim. The balance also changes where a dominant platform combines extensive data across services, and the user cannot reasonably expect that processing. In the Meta versus Bundeskartellamt, the court considered that users' interests and rights overrode Meta's interest in personalized advertising without consent. Subsequent Norwegian and EDPB action extended the practical prohibition on reliance on legitimate interest for Meta's work. Consent becomes the remaining route, but consent or pay raises the question of freedom. Zard does not claim that every pay or consent model is automatically unlawful. A model may produce valid consent where the alternative is real, equivalent, and fairly priced, and where users can choose another service without serious detriment. Gatekeepers create a harder case. Social networks can function as social infrastructure, and dominance limits realistic substitution. But Zard argues that Meta's $9.99 alternative did not provide a genuinely free choice. The chapter favors a third option, a free version supported by basic or contextual advertising, alongside personalized advertising by consent and a paid subscription. The 2024 Author's Note records that the EDPB's opinion 08-2024 adopted a similar concern about large platforms and meaningful free alternatives. Consent becomes still harder in the open ad tech ecosystem. A consent management platform can transmit a user's preference through the transparency and consent framework to hundreds of vendors participating in real-time bidding. The Belgium Data Protection Authority challenged whether one interaction could deliver specific and informed consent across such a complex chain. The problem is epistemic as well as formal. A user may see the number of vendors without understanding their identities, purposes, data flows, or later auction participants. TCF 2.2 moved the system towards consent rather than legitimate interests and added disclosure. But the chapter remains skeptical that that framework can satisfy Articles 4, 6, and 7 at scale. The author's note also records the CJAU's 2024 IAB Europe judgment. The e-privacy directive creates a separate legal layer. Article 5.3 generally requires consent to store information on or gain access to information from terminal equipment. That tracker consent does not itself establish a GDPR lawful basis for the later processing of personal data. The two questions must remain distinct. Moving away from third-party cookies also does not necessarily end surveillance. Device fingerprinting, browser-based profiling, and local advertising can preserve behavioral targeting while changing where data move. Privacy-enhancing techniques may reduce disclosure to third parties and lower confidentiality risk, yet they can also consolidate power in the browser or platform provider. The chapter therefore distinguishes privacy engineering from a complete answer to exploitation and market structure. Zard treats the data for access arrangement as a surveillance contract. The Digital Content Directive and consumer law can therefore supplement the GDPR with information duties and remedies where consent proves invalid. The analysis also moves beyond individual waiver. Digital Services Act's risk assessment and mitigation duties require very large platforms to examine systemic effects of advertising systems. GDPR's impact assessment, fairness, and accountability can reinforce that work. Consent may waive a prohibition on processing in some circumstances, but it cannot legitimize every threat to physical or mental integrity, dignity, children, non-discrimination, or democratic life. The chapter also argues that high-impact advertising involving employment, housing, credit, health, or gambling may trigger Article 22 and require explicit consent. Lawfulness remains necessary, but it is not sufficient. To me, the core takeaway of Lex Zard's chapter is that surveillance advertising, according to him, remained legally unstable because its business logic strains every plausible lawful basis. Contractual drafting could not create necessity, legitimate interest could not overcome less intrusive alternatives and rights, and consent remained vulnerable to dominance, opacity, and coercive choice architecture. Don't forget to check out the next video in this series, where we examine femtech, gendered risks, and why an apparently neutral risk framework can miss embodied, collective, and societal harms.